Yeah.
But to your point about secrecy, I mean, it really is undermining public trust. I think we had the government, you mentioned the Sechelt situation, the government signed the Sechelt Foundation Agreement renewal in August. They kept completely silent about it right through the election that took place last October. And only, I think it was February, that they finally came out and said, oh, by the way, we've signed this major agreement over 1.2 million acres of land that is problematic for a whole host of reasons. But we didn't want to tell you before the election because I guess we were worried about our election prospects. And
Yeah.
you have similar secrecy around the Heritage Conservation Act, which has big impacts for the economy, for private property as well. That they had local governments sign non-disclosure agreements because they didn't want the public knowing what was at stake. So again, and I could give so many other examples, but it's really been marked by a secrecy that I think undermines the public's trust in the process.
Carolyn Elliott is a senior fellow with the Aristotle Foundation for Public Policy. She sits on the board of the BC Public Lands Use Society. And more than that, I think no one's done better work on the Cowichan tribe's land decision and, of course, going into Haida Gwaii, et cetera. Carolyn, thanks for taking the time. And let me say, I've enjoyed your articles, your columns you've put in the National Post, because I think this is an issue that we really want people to be at least aware of. And it seems to me, while there has been decisions coming into that, I guess it was the August decision on the Cowichan tribes, most people were not aware of it.
I think that that's come into, they've become starkly aware, especially the landowners who received the notice from the city of Richmond talking about the potential impacts on their private property that led to a jam-packed town hall in Richmond on earlier this week. I think there were something like 600 people there.
Yeah, it's one of those things when it affects you personally, people start paying attention. And I'm not sure if I could think off the top of my head, at least, of anything that people would be more concerned about than whether they own their own land. The fee simple. Did they say there's both Aboriginal title and, fee simple title, which doesn't seem possible because they, have similar use of the land, who controls the land and things like that. So maybe just sum up what the fuss is about.
Yeah, so I mean, in August, as you said, the BC Supreme Court declared Aboriginal title over 325 hectares of land in Richmond. This is the first time a court has declared Aboriginal title over private property. So there were two previous Aboriginal title decisions that recognized that in different regions, private property was not part of the deal in those cases. So this is a very new thing, and on top of that, the judge also declared certain kinds of fee simple interests as defective and invalid. And most importantly, and I want to read from this has been brought up by a top Aboriginal law expert, Tom Isaac, in some other interviews he's done. And he first pointed me to this paragraph, and it is really concerning. It says, this is straight from the ruling, a precedent that will flow from this case is that Section 23 and 25 of the Land Titles Act do not apply to Aboriginal title. So these sections set out the rights that private property owners have over their property. And as Tom Isaac says, to put it bluntly, these sections are the heart and soul of fee simple property rights. So this goes potentially far beyond the Richmond area to the broader British Columbia property ownership landscape as well. So there's a reason people are worried and concerned.
Well, also the thing that jumped out at me when I first looked at this ruling, and it was brought to my attention by Robin Younger, who's been great with this show, that they didn't, the provincial government did not argue in favor of fee simple, over, or the rights in that court case. The federal government had started, but then withdrew that. So here you are. I mean, I think it could have implications like in New Brunswick. There's a lot of trials going on when the judge could simply ask, why didn't you argue in favor of fee simple at that point? I mean, I think as you say, the ramifications could go throughout the province of British Columbia, but maybe even further, at least as part of the context of other challenges.
Yeah, and I think the aspect of the case that you're referring to is based on a civil litigation directive that was issued by David Eby, the Premier of BC, but this is back when he was Attorney General, and he issued these civil litigation directives that essentially prevented Crown lawyers from making the extinguishment argument, meaning that the Aboriginal title was extinguished with the granting of fee simple interest, and that is one of the core arguments that you might make if you're interested in defending private property rights, one that was not made in this case. So that's an issue. We can also talk, if you want, about another factor I think that the government kind of put into play with this, which was the policy precedent in the first place of Aboriginal title over private property in the case of the Haida Agreement. And we can talk about that in a moment if you want to.
Yeah, but I wanted to come to that because again, that was out there, 2024, I believe, and yet that didn't get near the focus that this has, the Cowichan tribes, and yet that was the precedent, at least set by the attitude of the provincial government. That's why I find it difficult for the NDP to sort of throw up their hands and say, that they didn't have much to do with this.
That's exactly it. So we have them suddenly being very concerned about private property rights, and appealing the Cowichan decision, which is the right call, of course, to appeal it. But at the same time, they did set the policy precedent. I mentioned that this is the first time a court has declared Aboriginal title over private property. Well, that actually had happened from a policy precedent by the provincial government, not a court, in the Haida case, where they declared Aboriginal title over the entirety of Haida Gwaii, including the private property interests there. Many lawyers, including Robin Younger, including Tom Isaac and others, said, look, like, this is a questionable thing that you're doing with the Haida Agreement. You can't have two kinds of rights that confer the exclusive use of the land over the same piece of land, right, to two different parties. You're gonna run into problems. The government did it anyway, and even went so far as to just recently, in light of the Cowichan decision's massive impacts, then went to the courts and sought a consent order that essentially constitutionalizes the Haida Agreement and makes it very difficult to undo. So there's a whole bunch of layers to this that we can pull on any of those threads if you like.
But even, I'm thinking as a property owner, if let's say I owned the whole thing and I didn't have a mortgage, what about a mortgage holder? Because of course the mortgage is against the land, the house and the land. Well, that's got to set that on a lot of question marks, at least for a bank, if you're looking to renew your mortgage.
Yeah, I would think so. And I'm not an expert in that field by any means.
No.
But I have to imagine that this would come into play. It's one of the concerns that was raised by one of the landowners who was present at the Cowichan meeting, or the Cowichan ruling meeting that the city of Richmond held this week. And coming out of that, he said, look, like, I'm running into problems exactly the kind that you specified there. So
yeah.
I think that the prospect of this becoming even bigger in that sense is there.
And also the uncertainty. I mean, one of the things I always try to express to people, doesn't matter where you are on a political spectrum, people have to understand that uncertainty is not the conditions you want before someone commits their money. And it can be as simple as a bank. You start hearing rumors that the bank's going under, you don't put your deposit money in. I think this is going to be a huge freeze on capital investment, which was already discouraged from coming into this province. And so where do we go from here on this, though? I mean, you said that the BC government is appealing. That will take a while.
Yeah, and I think that's a lot of people's concern around this, is that even while we wait for that appeal to take place, you just have this situation of uncertainty. And as you say, uncertainty is like the antithesis of investment in a strong economy, and the job creation and so on that we want to see. So it throws a lot of that into question. I think it will take some time. And I think there's a broader question about where are we going with this more generally, right? And where's government policy leading us, not just in terms of sort of some of the things that led to the Cowichan decision, but with the Haida Agreement, with some of these land use agreements that they're signing. There's a whole bunch of things at play that affect our economic prosperity, that affect our democratic rights, that affect our sense of social cohesion. Like, there's really big fundamental questions as part of all of this. And I think if there's one thing good coming from this decision, and there's not a lot good, but if there's one thing good, it's that I think the public is getting a sense of really what's at stake here. And it opens up, I think, a moment for discussion and debate about what our future should look like in this regard.
And I think that government could be rightly criticized for not being upfront on a lot of this stuff. I mean, there's some things I can say, well, the public didn't make themselves aware, but there's other things I can say, they're working on agreements, off the top of my head, up in Sechelt in British Columbia, where all of a sudden, presto, here's the result. I hope it does. I really agree with you. I'm glad this is brought to the public's attention, because obviously the ramifications are, significant. But also that the government's got to be way more upfront about this. What have we signed on to? They did the UN agreement for the rights of Indigenous people, but did we know what that even meant at the time?
Yeah, and in that case, I think they've gone far beyond what they said it was about at the time. They were very clear at the time that I don't think ever should have been adopted, frankly. I just think that it set us on this path, and we're ending up in in a not great place. But when they did adopt it, it was unanimously adopted, as you know, and the government said, look, everything we're going to do with this legislation, we're going to do in keeping with Section 35, which demands ultimately a balance between the rights of Indigenous peoples and the unique interests of the Indigenous groups in question and the broader public interest. And I think that balance has really gotten lost in terms of the reconciliation approach as a whole. But to your point about secrecy, I mean, it really is undermining public trust. I think we had the government, you mentioned the Sechelt situation, the government signed the Sechelt Foundation Agreement renewal in August. They kept completely silent about it right through the election that took place last October. And only, I think it was February, that they finally came out and said, oh, by the way, we've signed this major agreement over 1.2 million acres of land that is problematic for a whole host of reasons. But we didn't want to tell you before the election because I guess we were worried about our election prospects. And you have similar secrecy around the Heritage Conservation Act, which has big impacts for the economy, for private property as well. That they had local governments sign non-disclosure agreements because they didn't want the public knowing what was at stake. So again, and I could give so many other examples, but it's really been marked by a secrecy that I think undermines the public's trust in the process.
Well, I got to tell you, we certainly appreciate the work you've done, nonstop work on that. And I'd invite people to look at the National Post where you're publishing, because I think it's time we were made aware of these things. You can see how significant the implications can be. Carolyn, thank you for your work and thank you for joining us today.
Thank you for having me.